Good evening. This is Laws 19038, Planning and Environment Law. This is John Milburn. It's week number 8, and this week we're covering a few issues. Firstly, a reminder, of course, that the first assessment piece is due by effectively midnight tomorrow. I hope that you're well advanced if you haven't already submitted your work. Don't be afraid of submitting something. Remember, of course, that the first 50% of marks are much easier to obtain than the second 50% of marks. So don't be frightened to the point where you're hesitant to submit what you have. Do so on time. Any applications after the event will not be considered for an extension. All right, so what we've been doing in this course is trying to blend some practical aspects with some aspects which are pure theory. And I guess it's fair to say that we've started from the theoretical perspective of what environmental law and planning and environment law means from an international level, and then we've brought it down to a Commonwealth and state level. And now we're looking more at, I suppose, the executive level, the way in which environmental law is implemented in a real scenario, not by parliaments, but rather regulators, and I'm talking here about essentially government. As we talked about before, there is a difference between government and the Crown, and I'll talk about that shortly. But just to give you an overview of what I want to talk about tonight, firstly, a very practical aspect dealing with the issue of practice directions in environmental litigation. And that's a follow-on from the discussion we had last week regarding planning and environment court rules. Secondly, I want to talk about the way in which environmental planning instruments are used by regulators in the context of decision making. And finally, talk about the need for environmental impact assessment, when it's required, and when it's actually what it seeks to achieve. So they're the three main issues for tonight's discussions. And as always, please feel free to come in with a question using the chat facility, or just join live by asking a question. Oh, there is an important issue. You may have noticed that you have an opportunity to provide some feedback for the course, and I'd encourage you to do that when the opportunity presents itself. So I'm just going to mute a microphone there. Thank you. All right. So feel free to ask any questions as we go. All right. So firstly, let's talk about the way in which the Planning Environment Court operates in practice. Now, this is critically important because what I'm trying to do here is create that link between the theory that you'll read about in the textbooks with the actual hands-on way in which litigation is conducted. Part of the assessment pieces that I ask you to do are a blend of the theoretical and the practical. So when I ask you to look at a case, I'm really getting you to look at it at a real-life scenario of showing the way in which environment and planning and environment law is implemented. So last week we talked about the rules that relate to the conduct of litigation in planning and environment court litigation. Today, I'm being a little bit more specific and talk about a thing called practice directions. So if in any way you're involved in planning and environment court litigation, it's critical that you're aware of the practice directions and you comply with those practice directions. Now, of course, it may be that you say, well, that's for the lawyers to determine. Given that this is primarily a law course, of course, I need to talk about those sorts of things. But it's not just the lawyers that need to be aware of the practice directions. It's really anyone who is involved as a stakeholder in litigation that needs to be aware of what the court expects, and everyone will have their part to play. So I've selected 3 practice directions. I'm going to speak very briefly about the first 2 and the third in a little more detail. The first thing is, you have to get your head around what is meant by a practice direction, what does it actually achieve, and importantly, how do I find them? Now, I'm going to be a real nuisance and not tell you how to find the practice directions, But as an exercise, I'd really like it if you could find those for yourselves. I'll give you a hint. If you look on the court's website, you'll probably have a good idea. But if you can find those practice directions, then perhaps through UCrew or Moodle, you might like to engage in some discussions about them. So the first one is practice direction number 1 of 2011. And this is in relation to the process of early resolution of two types of disputes. That is infrastructure charges disputes and development approval conditions disputes. The reason I'm telling you this is that it may be that there are specific directions that relate to a particular type of dispute, and you need to be aware of that. So in this particular instance, there is a requirement that within 1 month, it's a very short period of time, within 1 month after commencement of proceedings in relation to those two types of disputes, the practice direction requires the parties to either participate in or fix a date and time with the ADR registrar for participation in a mediation or a without prejudice conference chaired by the ADR registrar or a case management conference chaired by the ADR registrar. So the point about that is three things. The first is that there may be specific practice directions that relate to a particular dispute. The second is that there are likely to be very strict time limits that you need to be aware of. And the third is that the practice directions work with the rules in the conduct of a matter. So last week, we talked about the way in which the ADR process is regulated in the rules. So you need to be aware that the practice directions may also have some relevant commentary in relation to those issues. The second practice direction that I want to talk about is number 12 of 2013. And it's a pretty simple practice direction, and it talks about the way in which authorities, meaning cases, are cited. Now, we've talked about citation of cases, we've talked about the Australian Guide to Legal Citations, we've talked about Harvard referencing, etc. And you'll recall from the outset that I talked about the fact that there are some authorised and non-authorised publications or reports that are available. And in this particular practice direction, essentially what is required of practitioners as far as the court is concerned is to ensure that only those authoritative and functional versions of relevant authorities are presented, and parties are limited in terms of the way in which they cite their authorities. Essentially, the court wants to get to the right decision as quickly and efficiently as possible. What they don't want the litigants to do is provide a bundle of 50 cases to say, well, my argument is that the precautionary principle should be applied in this case, and here are my authorities, and here's 50 cases where the precautionary principle was applied. Courts don't like that. What they want you to do is say, this is the particular case which established a principle or a proposition that is being relied upon. And what they don't want is to have countless authorities presented which simply rephrase or illustrate or apply those principles. So it's the lead case which is important as far as the Planning and Environment Court is concerned. And the other thing is that the court encourages, or in fact directs, the litigants to provide a citation for the authorised report rather than the unauthorised. So in Queensland, the Queensland reports are the authorised citations. All right, now the next issue is in relation to practice direction number 2 of 2014. And in that, the Planning and Environment Court comes up with a number of very important practice directions. Now, it has some definitions. It talks about dispute resolution plans. It talks about pre-call-over reviews, and they're referred to specifically in the context of what we call directions orders. Now, what the heck is a directions order? When litigation commences, it will start with an application, and typically a direction is made by the court as to the appropriate conduct of that matter. Now, generally in litigation, these things can occur at a reasonably relaxed pace, but not so in the Planning and Environment Court. In the Planning and Environment Court, parties have specific obligations to undertake within a very short period of time, and they're quite onerous obligations. So this particular Planning and Environment Court practice direction says that within 6 weeks of the institution of proceedings, an application for orders for directions about the conduct of the matter must be brought, and in that the parties are provided with some guidance as to what is to be included in that directions order. And the draft order is prepared, preferably with the consent of both parties, but it's prepared and presented to the court as a guide to what the parties would like the court to do by way of a direction about the conduct. So in that draft order, you need to include material regarding disclosure. We talked about disclosure last week. The extent to which the evidence will be by way of affidavit, statement, or oral evidence, whether expert evidence will be adduced, and if so, whether it will be a single expert engaged jointly by the parties, or if the parties propose to have separate experts, an exchange of list of experts in their field of expertise, the way in which the meeting of experts and production of joint reports will be prepared and presented, whether there will be a meeting of experts, conclave if you like, that we talked about last week, chaired by the ADR registrar, and an exchange of expert statements. Now, what does all that mean from a practical point of view? Essentially, it means this, that if you're a party to litigation or an advisor to a party in litigation, either as a lawyer or otherwise, you need to be aware that within 6 weeks of commencing the proceedings, the court wants to know a lot of specific detail. They want to know, who are your experts? Will it be a joint report with the other side? How is the ADR process going to be managed? How is the litigation going to be managed and the evidence produced? That means that there's a lot of thinking and planning that has to go on at a very early stage. Now, the reason I'm stressing that is that if you're a litigant who is not legally represented, that's a very daunting task, so it's an impediment to self-litigants. And if you're a party to litigation, you need to be aware that your lawyers and advisors are going to have to work very quickly, and of course you need to be aware of the costs associated with that right from the get-go. And you need to know that before you even consider lodging your material in court. Okay, so that's really essentially the more practical aspects of what I wanted to talk about tonight. Are there any questions or comments? Otherwise, I'll continue. All right, feel free to interject at some stage if you like. Now, the second thing I wanted to talk about was the way in which environmental planning instruments are used by regulators. So we talked about the separation of powers. We talked about the way in which Parliament introduces the laws, the way in which the executive administer the laws, and then finally the way in which the courts come to make decisions about disputes. So we're really talking tonight in this context about that second level, the way in which regulators use planning instruments, which are created through legislation, in the process of making decisions. It's really essentially a follow-on from the discussions in Chapter 8 of Bates, where the author talks about the process of strategic environmental planning. And you'll recall that in that chapter, Bates talks about the allocation of Crown land and resources, and talks about the way in which environmental management plans are used by regulators to appropriately manage natural resources vested in the Crown. So I'll just stop there. You remember I tried to make the distinction between what is the Crown and what is the executive or the government. So the government is elected each election. The administrators, the executive, are appointed bureaucrats, if you like, public servants, and those people change, as do politicians. But what remains constant is this concept of the Crown, and in particular the concept of land and resources which are vested in the Crown. And I've used the parallel of the people that are in a house as opposed to the household. The people in the house, the executive, the household is the Crown. It's that thing that's always there, irrespective of the individuals within it. Okay, so when we talk about the executive, we're really talking about the way in which government regulators monitor and control the process of development and development approval. And it's through the imposition of that control, through licensing, through making decisions about development applications, etc., that planning and environment law is made and created and implemented. So how do the administrators go about dealing with their task? Well, firstly, they are required to comply with certain obligations which are found in legislation and also planning instruments. So at the state level, we have the state planning scheme provisions, the standard planning scheme provisions, and then of course we have the regional and local instruments below that. So the government regulators are given a framework about which they make their decisions. And part of their decision-making process is the way in which they consider managing environmental impacts for developments which are put forward. Can I just say that it's at that early stage when these plans are created, these planning instruments are created, that members of the public have probably their best opportunity to have their say in relation to environmental issues. Anyway, so these environmental planning instruments can be introduced, say, through the Sustainable Planning Act, and they allow decision makers to ensure that the decisions they make are consistent with the general purposes which are enshrined in the Act. So, in particular, have a look at, say, sections 5 and 8 of the Sustainable Planning Act, and you'll recall the concepts of ecological sustainable development and some of the issues which are inherent in ecological sustainability, such as the precautionary principles of intergenerational equity, ecological integrity, etc. So those general principles, which sometimes are created at an international level and filter their way down to a state level, they're introduced by Parliament, but it's up to the regulators then to make decisions which are consistent with those general purposes which are referred to in the Act. And as mentioned, the regulators need to look at the state level instruments, but also the regional and local planning instruments in that regard. So the exercises that I've given you in the assignment work are intended for you to firstly understand the general principles, but then more specifically make reference to the way in which these things are considered in a real situation. So one of the key ways that regulators deal with development applications, for example, is through the use of environmental assessment procedures. And that's referred to in Chapter 10 of Bates' book and introduced in Chapter 9. So the question then is, to what extent and when do these environmental assessments need to be considered by regulators? It's important to understand from the outset that under planning schemes, not all proposals must be the subject of a full assessment. Indeed, you'll recall that developments may be classified in different ways, and that will have a bearing on whether assessments are required, and if so, to what extent. So, by way of refresher, developments may be classified as permitted, development that does not need consent or is exempt, complying development, prohibited development, or development that does need consent. So they're all different types of development applications and all may have a different status. Last week, you'll recall we talked about sections 231 and 235 to 238 of the Sustainable Planning Act, which talks about the different types of developments. So have a look at that and get a feel for what type of developments, for example, need consent. So when we're talking about environmental impact assessment, we are generally talking about those development applications which require consent. A couple of things though. Just because a development does need planning consent does not mean that it necessarily needs a full environmental assessment to be attached to it. And conversely, just because a development does not need planning consent does not mean necessarily that environmental assessment is irrelevant. But generally speaking, when we're talking about the formal process of environmental assessment, we're talking about developments that need consent. Okay, so when a decision maker is called upon to consider an application for development consent, the question is, to what degree, if at all, are environmental factors to be considered? Well, the fact is that environmental factors are the prime, but not the sole concern of the decision maker. Proposals that are likely to involve significant environmental effects may be required to undergo a formal process of environmental impact assessment, but even then, that's not the sole criteria of the decision that needs to be made. The other thing is, bear in mind that this whole process of decision making at a government executive level is subject to the IDAS system. So in Queensland, the Integrated Development Assessment System integrates the decision-making process for approvals under the Sustainable Planning Act. And you'll recall that the IDAS system has several stages, which involves the application stage, the information and referral stage, the notification stage, the decision stage, and the compliance stage. I'm getting close to the end of what I want to discuss tonight. I'll just talk about a couple of other issues. One is the possible use of planning agreements. And if you're an advisor to a person involved in a development application, you should always consider perhaps the use of planning agreements as a way of getting around issues that otherwise might create a deadlock. So these agreements are made between a developer and a consent authority. And the agreements provide for maximum flexibility, allowing for the parties to come to an agreement which doesn't strictly necessarily fall within the guidelines, but provides some perhaps mutual benefit. The other thing that I should mention is that in addition to the usual process, the IDAS process, there is the opportunity in some circumstances to seek a fast tracking of a major development. So in Queensland, over the years, that type of approval or fast tracking major projects has created some considerable controversy. And in that regard, refer to the State Development and Public Works Organisation Act of 1971, and that will provide some guidance in relation to the process of fast tracking a development application in those circumstances. When you're looking at that, also have a look at the powers of the Coordinator General in relation to dealing with those development applications. All right, thank you very much for your patience tonight. It's been a bit meaty. I hope that it's been useful in an overall sense. Remember, of course, that what I will be doing progressively is reviewing each chapter of Bates' book, and I hope that that's a useful way to glean my thoughts on what are the most important parts. You may agree or disagree with the way in which I've reframed or summarised or paraphrased what is being said. And you may agree or disagree with some of the comments that I add to supplement that. So feel free to adopt your own interpretation. But what I do in those to-camera sessions is essentially designed to assist you with your reading, because I appreciate in this course there is a lot of reading to get through. Okay, so finally, remember, of course, that when the government regulators make a decision which is not popular with the applicant or indeed objectors can appeal to the Planning and Environment Court, where there would be a determination by that court on the merits of the application. We called it a merits review because it means that the court effectively steps into the shoes of the decision maker and makes the decision afresh. So a lot of people that are complaining about council not having done this or gone about it incorrectly kind of have the wrong approach when it comes to litigation, because in the Planning and Environment Court, what you need to do is essentially present all of the material afresh, and it really doesn't matter what the decision maker at first instance did right or did wrong, because the judge in the P&E court will start afresh and make his or her own decision completely. Okay, well, that wraps up what I have to say tonight, unless there are any questions or comments. Thank you for your attendance, and see you next week.